Interest in real property. I wanted to get to this because this is always kind of fun. This is my cup of tea, actually. I mean, I'm a real estate title attorney. So when we're talking about interest, this is what I do all day. Find solutions to problems. So let's give the background of ownership. All right, there's many different things that go into owning real estate. It's not as simple as being the owner and you have all the rights, because you don't. It's, as they teach you in law school, it's a bundle of rights, like you could bundle of sticks, right? And you start out with, a bundle of 50 sticks, and you take out 20 of them, and what your clients are buying is only those 30 out of those 50. You know what I mean? There's a lot of other people that have some sort of right or interest in that property. First one being real estate taxes, second one being utility easements, third one's being right-of-ways, building setback lines, covenants, conditions, restrictions. You can't have a chain link fence on your house. It's got to be white picket. You got to have the, landscaping run by the association's approval board, et cetera, et cetera. Those are all rights in real estate. So when we're talking about ownership, we're looking at, maybe a fee simple, maybe a life estate. It could be an easement. It could be a mortgage or other type of lien, like a financial claim. But possessory interests are broken down and sort of described as estates. So if someone has an estate in real estate, that means they have an ownership, or they have a possessory interest, okay? So you could have a leasehold estate. I am the tenant in the property, therefore I have a possessory interest. There are present interests and future interests, okay? So you could have reversions, you could have remainders. And I just dealt with this actually 2 weeks ago in one of our files. We had a situation came up where they wanted to do a life estate, and I was trying to talk to them about maybe doing a TOD affidavit that we talked about earlier instead of a life estate. But basically, what is a life estate? You have A to B for life, and when B dies, okay, the property would revert back to A. So if I gave someone a life estate, I am giving them a possessory interest for their life. And when they die, it would come back to me unless I named a remainder interest, which would say A to B for life, remainder to C. Okay, and that's what they wanted to do. They wanted their children to have the remainder interest. And so we talked through all that, and we ended up doing it for them because they were insistent that they thought that was the best way to go. And so it still happens. It's out there. You may not see it often, but it is, especially kind of outside of metropolitan areas, where you have family farms and family, history and things like that. So to move quickly through different types of rights, let's hit on dower rights. How many people here feel like they have a good handle on dower rights? Hands up. Okay. Anybody willing to admit that they're not sure that they really have a good handle on dower rights? Okay, good. All right, we got somebody brave enough to say that it's confusing, because it is. It actually really is confusing. And most people will probably think it means you have a half interest in something. No, that's not what it means. It means you have a 1/3 life estate in the real property of your spouse. So if your spouse dies, dower rights actually kicks in, and you can elect to exercise your dower right by choosing to go against your spouse's will and choose to take your dower rights. So it's very rare. You actually have to disagree with your spouse's will and contest it and go against it to exercise dower. So it's a very contingent right. It can only be used if your spouse dies. But yet we have to deal with it on every transaction.
Wait a minute, it doesn't kick in if a spouse owns a property totally in their name and they try to sell that property?
It does. It is a contingent. It is. Dower is contingent and doesn't vest until death. That's what I'm saying. So the person who holds the dower rights has no current right. The right is contingent upon death. So it exists, and the risk and why you have to release it on mortgages and third-party sales is because if you don't, and that seller later dies, and they never got the spouse to release their right, they now have a dower right that they can come back and trump whoever the buyer was. So the whole purpose of this is that if I'm married and my spouse owns title to real estate in her name only, and I did not release anything, I still have a right in that. And if she dies, I can basically come back in and claim a 1/3 life estate, which nobody in the law really actually even knows what the heck that is, but we treat it like a life estate, okay? It's very rare that anyone would actually do this, but it's like they have a life estate. So basically, I get to live in that property until I die. So even if there's another buyer that comes in, I have a superior prior interest to their interest, and they would lose out on title of that property, and I get to move in, okay? And I could kick them out. So that is why you have to always get dower rights released anytime you're conveying it to someone else or anytime you're mortgaging it, because you don't want a spouse to ultimately come back and block a foreclosure or block a sale or trump their rights down the road.
Well, but the same example though, let's say you got a husband and wife and she owns a property in her name, decides to sell the property, and he's asked to sign off for dower, and he refuses. That can stall, that can stop the sale of the property.
Correct. And that's the purpose. So the question is, what do you do when you've got a spouse who doesn't want to release their dower rights? And how is that fair? And I would tell you that that is the origination of the law itself. The whole point of dower was so that a husband could not sell a property without the wife's consent. So if you're married, you've got to act in tandem. You cannot act independently. You have to act together. So if you have a client who owns property and they are entitled by themselves, but they are married, legally married, even if the spouse moved out 15 years ago and they don't know how to find them, they are still married and they have to act in tandem, or you don't have a fully enforceable contract or an ability to close, because the spouse has to sign off on everything.
And do you need the spouse to sign like the original purchase contract and everything, or do they just sign off on the closing if they're not made up to you?
It's a good question. I get asked that a lot. And I would say, basically, yes, best practice, have them sign the contract because they have a right in the property. Then you don't have to worry about it because they're on the hook too. But keep in mind that just because you don't doesn't mean you can't move forward and get them to release the dower, sign a quitclaim deed to the third party. They cannot quitclaim their dower to their spouse. Remember, it protects one spouse from the other spouse moving the property out of their name without them approving. And you cannot just waive your dower rights. Okay, so it's impossible for a spouse to give away their dower rights to their spouse. It can only be terminated by releasing it to a third party on a deed or a mortgage or something like that, by court order, okay, or by death. Once the death is over, you're no longer married and you no longer have dower rights in anything. You just exercise that life estate on the prior existing property of the deceased spouse.
And this would not apply to premarital?
Correct.
And it would not apply to inherited?
Let me correct you then, because basically what you were just asking though says, does it apply to property bought prior to marriage? Well, yes. As soon as you are married, it applies. So if you bought property in 1999 and you got married in 2002 and now you're selling it, dower rights apply.
I disagree with you.
Okay, why is that?
Because in Ohio, isn't it true that you can, as long as you do not commingle assets?
It doesn't have anything to do with divorce. It doesn't have anything to do with that. It applies no matter what. You do not have to know when they were married. The issue is, are they married now? And if they're married at the time of sale, you have to have them sign off, or at the time of refi, it would apply then as well. And so here's what most people try to do to get around that. They file for divorce prior to the sale, but that doesn't do anything. That doesn't terminate dower. You actually have to have the final decree to terminate the actual dower interest. And so this also applies to same-sex marriage in other states. We're seeing this quite a bit. And so just yesterday, we were getting a title situation resolved, and one of the people that had to quitclaim their interest was now same-sex married in another state, and Ohio honors that. So we had to have the same-sex spouse come in and release dower on this transaction, and everybody was very confused by that, but that's the way that it works. Ohio is one of 4 states that has this. It does not work like that in other states. It only is basically Ohio and Midwestern, like Kentucky in Indiana. And so you've got to worry about that here. But in a lot of other states, they have homestead. And so the only time dower really applies, or the concept similar to dower, is on primary residential property. It doesn't apply to investment property or anything like that. It's only the primary residence. But Ohio doesn't have that yet. And I'll tell you, though, that there is actually momentum in the Bar Association and in the probate section, in the real property section, to change dower laws, to actually find a way to do this that's more like other states. So it's kind of a hopeful thing, because it is kind of a pain in our butt. So, yes?
Another question related to the whole divorce thing. Couple is in the process of getting a divorce. Husband buys house for current wife to the ex-wife. In her name, deeded in her name. But obviously, he still has dower rights, so does that final decree of divorce then remove his dower right, and is any kind of quick claim needed to fully get him?
No. If a person owns title to a property by themselves, and there's a dower right that exists, if a court order is entered to terminate the marriage, dower automatically goes away. You no longer have it. So therefore, any future transactions after the divorce decree date would not need a dower release or a quitclaim or anything like that. Okay? The problem is more along these lines, and this is a common situation that's not really dower related, but it's marital and divorce related. And so when a couple gets divorced, but both people were on title, okay, that's when you need a quitclaim to remove someone from title. So here's a classic example, and I had this one recently. You have husband and wife on title, they get divorced, they have kids, so wife and kids stay in the house, husband moves out, right? It's most of the time that's how it goes. And so they got divorced, and the husband then was like, okay, I'm not supposed to be liable on the mortgage. Wife's maintaining the mortgage. I'm supposed to quitclaim the house. So he quitclaims the house. He signs a deed, gives it over to her, moves about his business. Okay? Then all of a sudden, a year or two later, he starts getting collection notices, and he checks his credit, and his credit's ruined. And they call me up and say, I want to sue her, and how do I get my credit fixed? And I have to tell them, okay, well, you need to go back to your domestic attorney because she's in contempt of court. If she hasn't refinanced you off the mortgage, well, then you have a problem. But you never should have quitclaimed it in the first place, and you never should have thought that you were out of responsibility. Because just because you got divorced doesn't mean that the lender has to all of a sudden not be reimbursed by you, right? If you sign a promissory note to the lender, you're liable on that. So when husband and wife signed it, the divorce does not do anything about that note. And so the best practice is that as soon as practicable, they either sell the house or the remaining spouse must refinance, and upon the refinance, the other spouse will quitclaim, and the title company holds that in escrow until the closing and then records the quitclaim in the new mortgage. And then it's done simultaneously, and you can avoid that problem. But
by the same token, don't front-end load the transaction, meaning you're going to refinance the property out of a spouse's name and do the quitclaim deed through the title company. It doesn't really solve the problem.
I'm sorry, I'm not sure I 100% follow what you were saying.
We have clients who call in and say, well, guess what, we're going to refinance this property before the divorce is settled.
Yeah, before the divorce is settled, exactly. Again, dower applies till the divorces end. So what happens is people try to buy, they file for divorce and then they want to go refinance prior to the divorce decree. It doesn't work. Or they go buy a condo. The husband moves out and goes buys a condo. Well, his soon-to-be ex-wife has to release dower on the condo mortgage because the lender needs priority position on that. Because the fact pattern goes is that if he buys the condo prior to the divorce decree, he dies, she now has dower rights in the condo he just bought. And that would trump the buyer's lender, or the husband's lender. So basically, you got to do everything after the divorce, but you got to make sure that the domestic attorney does things correctly. So a lot of times, they should if you're involved in that situation, make sure they know that, hey, does your domestic attorney know how to handle the real estate? You should ask them questions about that and prod your client to make sure that they talk about it with their domestic attorney, because that's usually the call I get, is they never talked about it and they didn't know, and that's a problem.
Going through a divorce and he's having me look at condos for him. He is not divorced yet.
Yeah.
I understand that she will have dower rights until the divorce is
Yeah.
final.
So when he gets a mortgage loan and goes to close, she's got to show up at closing to release her dower on that mortgage.
She has to be there on day of closing.
Well, the loan docs will be dated the day of closing, so she could come in at 9 a.m. and he could come in at 10 a.m. They don't have to be jointly at the same time, but they got to sign that same document if he buys it before the divorce is final.
So she needs to sign off her dower rights, even though they're not divorced yet.
Correct, because the divorce is what terminates the dower.
Okay.
Just think divorce first. That'll make
Yeah.
it a lot easier.
Yeah.
Divorce first, yep. And we are about out of time here. I'm just trying to think if there's anything else worth mentioning real quick. Liens. Okay, one thing that's important to understand about liens is that there are general liens and there are specific liens and there are voluntary and involuntary. A mortgage is a voluntary specific lien. It's granted voluntarily and it's only specific to the legal description of the property on which it is being placed. But judgment liens are not voluntary, they're involuntary, and they're general. They are valid against a person and anything that person owns. So when you have a client with a common name, Michael Williams or something like that, okay, you can expect that we're going to have some problems with the title search because we're going to find a whole bunch of liens out there against various Michael Williams. So make sure they always use their middle initial, that we're going to have to know their date of birth. We're going to have to know a lot of information because we're going to have to clear all those. And they're probably going to have to sign an affidavit at closing saying that they never lived at this address and this isn't them and all that. Because liens are filed against people, okay, not just properties. And so don't just be confused as to, how does that lien, why are you asking me that? Isn't it against the house or not? Well, no, there's different types of liens. Mortgages are against property, but judgment liens are against people, and they would just stick on or attach to any property they own in that county at the time it was filed. So with that, I will end. I believe we are out of time. Please make sure that you initial out. Join us at the happy hour. And if you'd like to ask me any questions, I'm happy to stick around for a few minutes and field questions. So thank you very much.